Okay, welcome to Renew Missouri's CLE. The topic today that we'll be covering is homeowners associations and the new and changing laws surrounding solar photovoltaic systems. And we're calling it what real estate professionals need to know about Missouri's new solar laws. I think James Owen, Renew Missouri's executive director, had a snappier title for this. Tori, what was he calling it? I think he said
This is what he called it in the presentation, but the title of our event was different.
It's always sunny in your HOA, breaking
Yeah.
down Missouri's new HOA solar law. So that's what we'll be covering today. It's timely, and I think it's to summarize quickly, we've had a long struggle between people who are on the homeowners association side and want to manage their communities, including how people get their energy on one side, and on the other side, a property owner based regime of everybody who owns property has the right to install solar, and the Missouri legislature kind of breaking that impasse and landing decisively on the property owner's side. And we'll talk about the implications of that new law and what it means for homeowners associations, what it means for homeowners, and what might be coming in the future. So welcome, everybody. We are recording this. I think a lot of you will be watching this on replay. We have some of you live, perhaps more people will join us. But we're glad to have you. So here's a quick agenda of what we'll be covering today. I'll do some introductions and introduce myself and my co-host here. And we'll do a little recap of where we've been on this history of solar and property rights and homeowners associations. And then
Andrew,
we'll talk. Yes.
Sorry. So Tyrone said he lost audio from us. Tyrone, can you hear us?
Yeah, it's probably something on your end, Tyrone. Tori and I can hear. Deanna, can you hear us?
Yes, I can.
Okay. So Tyrone, good luck. I hope you can sort that out. I'm sure you can catch up on the recording later. So okay, so after a quick recap on the history, we want to talk about this new bill, which is Senate Bill 820, Missouri Senate. You can look at it passed and I believe in effect as of August 28th. We'll talk about how people might go about complying with that new law, and then we'll conclude. We'll have some time for questions at the end, but really, for the people on, we have a small enough number where anytime you got a question, please, you can throw it in the chat and Tori can alert me to it, or you can pipe up if there's a natural stopping point. So go ahead there, Tori. Okay, so quickly, if you're not familiar with Renew Missouri, we're a nonprofit, been around for about 15 years in Missouri. We're a clean energy advocacy group. So we do policy work around energy efficiency, renewable energy, low income issues of equity. We do statewide work, which means, the Public Service Commission that regulates utilities, and work in the General Assembly and the legislature. Also, Tori and I represent our St. Louis office on the eastern side of the state here. So we do some local work with the Board of Aldermen, the County Council, also with, direct relationship with utility companies and solar companies and wind companies and all of this stuff. We just recently got a lot more involved in rural electric co-op work in something called the Rural Power Coalition, which I think you'll be reading a lot more about here in the months and years to come. And also I represent a coalition called Energy Efficiency for All, the Missouri Coalition of Energy Efficiency for All, or EFA, which focuses on energy efficiency and equity issues for low-income people and multifamily renters. So yeah, and I already mentioned we do this work with utility companies, also with consumers, and so that's a little bit about us. Go ahead, next slide. As for myself, I run our St. Louis office as regional director. For a long time, I was our kind of our general counsel role, our staff attorney role in the Columbia office, and now I'm in St. Louis. So I'm doing a lot of local work. As I said, I work with the Energy Efficiency for All Coalition, but I still am involved quite a bit in rate cases at the Public Service Commission, and then energy efficiency cases and IRPs and things of that nature. I live in South City myself, and as does Tori, and our office is on Grand there by Grand and Arsenal by Tower Grove Park. I'll have my contact info at the end here as well. Okay, so we're going to look a little bit about the history of this issue and where the conflict arises between the property right to install solar and homeowners associations or covenants or other agreements or restrictions on the right to install solar. We'll figure out how we got here. I think most of you should be familiar with the concept of covenants, real property covenants, and you know, all the way from racial covenants to covenants to not sell, you know, like within a number of years. I mean, all of this stuff has a checkered history, but it includes solar dating back to the 70s. There was always been a concern about the aesthetics of solar, about whether they work, about what it conveys in a community. And as many people have been wanting to spread the technology, there's been probably more people until recently who wanted to restrict it and manage it and have a say over it. You know, solar panels used to look a lot like this big black rectangle. This is, of course, from famously from the movie Back to the Future. If you guys have all seen it. No, I'm kidding. This is 2001, Stanley Kubrick. The monolith, Stanley Kubrick. Yeah, solar panels have come a long way. They are a lot flatter now. They fit right flush on your roof. They even have shingle products now that look like a roofing service. Those aren't really installed in Missouri. They're not, if you ask me, they're not as practical. I think just your traditional solar PV is still the way to go, bang for your buck wise. But you know, solar panels are a lot more attractive now, a lot more financially stable and better investments. So their installation has accelerated dramatically in the last 20 years, as I'm sure everyone's familiar with. One of the laws that we want to be looking at here is section 442.012 in the revised Missouri statute. And this essentially declares the right to install solar is a property right. And that's been in the place since the 70s. We'll look at that on the next slide here, but that really comes in conflict with homeowners associations and their ability to decide what is aesthetically pleasing. Their architectural review committees and whether they have the ability to you know, make these sorts of regulations around what their members can do with their properties. Of course, the right to install solar, even if it is an absolute right, you can always sign away your right by contract. So we'll be looking at that as well, and how that's different from an HOA covenant. Okay, so I think we're ready for the next slide there, Tori. Okay, so we want to look first at this solar as a property right statute, which a lot of people probably aren't aware of. I remember when I started in this business about 10 years ago, we had newly discovered this, right? We were starting to see this conflict with HOAs banning solar, and we were looking for a way to figure out whether homeowners had recourse, and we discovered this statute. It had no reason to be enforced, basically, because nobody was really adopting solar at a very fast clip. But this statute says the right to utilize solar energy is a property right, but eminent domain may not be used to obtain such a property right. Okay, so it's explicitly recognizing solar energy as part of the rights that come with a property owner's right to utilize their property. So it's interesting. I'm not sure if a lot of states have these statutes on the books, but this one is seemingly pretty clear, but then difficulties come years down the road as we see. Let's see. Okay, so I think we're ready for the next slide. Okay, so here's some issues confronting homeowners. Prior to the 442.012, bans on any kind of solar would be seen in, covenants that run with the property that you adopt as you purchase your property. However, that ban changes that because it explicitly recognizes solar as a property right. And it's unclear whether those covenants would be illegal now, backward looking illegal, or how they would be enforced. The covenants would be silent mostly, and simply say that any change to the composition of property would have to be approved by a architectural review committee or similar bodies within HOAs. Where that became an issue, they would tend to be silent after that 79 statute. But most of the time there isn't any guidance for solar, and as we'll see here, solar, where it is mentioned, is typically just punts it to the committee in charge of those sorts of things. So as we get along here, we'll show you a sample HOA agreement and some language that can basically enforce the new statute on the books, Senate Bill 820. And how we might what we're recommending is that you explicitly address solar and you put forth reasonable restrictions, reasonable regulations on the installation of solar, so that it does away with all the doubt or the lack of clarity around solar. Because in the past, solar has not been it's typically not been dealt with explicitly by the homeowners association agreement. Okay, next slide there, Tori. Okay, so when you see this ACC shortening here, what's the word I'm looking for? The contraction. There you go, acronym. This typically stands for Architectural Control Committee, or there's other names for it, but essentially it's a subcommittee of a homeowners association that is in charge of the architectural regulations around what you can do to a house. So there'll be possibly a historic nature to, or a historic character of a neighborhood, of a homeowners association, and that they want to preserve, or they want to restrict certain types of additions. They want to restrict you from being able to have a fire pole on the side of your house, or put a big satellite dish on your roof, or these sorts of things. And these bodies exist in almost every HOA. So it's going to be important to that body how they deal with solar. A lot of restrictions have no guidance in how solar arrays or collectors could be reviewed, or what type of systems could be approved. That basically, like, even where homeowners associations or their architectural control committee outright bans solar in Missouri or elsewhere, they don't really have any guidance on what is banned, or like whether there is any feasible way to install solar. For example, could you do a ground mount way in the back of your house that's not visible from the street? That sort of detail is rarely articulated in the documents for organizing an HOA, and instead they kind of punt it to one-off decisions of these ACCs. And, you know, this brings in personal biases. This brings in the, you know, the specific viewpoints or grudges or other feelings of members who sit on these ACCs. And believe me, we've seen this. We've seen this play out where, you know, there will be a restriction in the HOA about solar, but the ACC has some friendly solar people on there and they just don't enforce it, and things get installed. Or the converse, where the HOA agreement is completely silent on solar, except for saying, you know, the Architectural Control Committee is empowered to enforce, you know, certain architectural standards, and a solar ban is imported through that. So this really, that sort of lack of specificity leads to arbitrary denials, a lack of a clear direction on how solar needs to be dealt with. And I think the statute that was recently passed will change that. But we have some specific recommendations for how that's done. Sometimes, you know, the homeowners association or the ACC will ask the landlord to go through all these ridiculous steps or take on additional expenses that make the solar payback infeasible. Or they'll ask, you know, to get permission from landowners, and then landowners have their own spite or biases or personal histories, and it's just not a rules-based regime a lot of the time. And then, you know, sometimes this spills over into the courts, and the courts will have to enforce this, and they're looking at all these documents from the HOA that are worded strangely, and they have to hear testimony from neighbors and sort through all this stuff. So it's an inefficient way to regulate what is a universal problem, which is where is the dividing line between the state right to install solar, the homeowner association right to regulate the architectural character of the neighborhood, and all of these issues. So that's what we're going to be going through now as a state. Next slide. Okay, so that's a little history. You know, solar, even though it's a global and well-established and many billion-dollar industry, is still fairly new, just since the 70s, and really since the mid 2000s, when it's really been an actual industry where the uptake has really been accelerating. And we finally have had to deal with this. This has been in front of the legislature, I would say, since 2012 or 2013, this issue. Folks like Senator Jason Holzman, who's now on the Public Service Commission, and many others have spent some time dealing with this Solar Bill of Rights, as sometimes it was called. And finally, it came to a head here in the context of a larger negotiation. Senate Bill 745 is another big package that upends the traditional way that utility regulation is done, and includes this net metering task force, which is solar adjacent. But also, as part of this, Senate Bill 820 passed. And it provides provisions to protect homeowners' solar rights. So we already have the solar as a property right line from the 70s, but this really adds additional protection and makes clear in that conflict between local, you know, you're signing an agreement with your homeowners association. Does that control over the property right? This really picks a side there and comes down on the side of property rights. So the controlling provision here is no deed, restriction, covenant, or similar binding agreement running with the land shall limit or prohibit the installation of solar panels or solar collectors on the rooftop of any structure. And you can look at Senate Bill 820 if you're curious about some of the definitions in here. Solar panel or solar collector is defined as a device used to collect and convert solar energy into electricity or thermal energy. So that's solar PV or solar hot hot water, including but not limited to photovoltaic cells, panels, solar thermal systems. There's a couple other interesting lines in here. The big one is, so I read that first line that you see here on the slide, but the next one is a homeowners association may adopt reasonable rules subject to any applicable statutes or ordinances regarding the placement of solar panels or solar collectors to the extent that those rules do not prevent the installation of the device, impair the functioning of the device, restrict the use of, adversely affect the cost of, or the efficiency of. We'll be talking about that more, but the key word there is reasonable rules, reasonable restrictions, you could say. So that's a really important piece that I would actually expect there to be some regulations that will further spell out. But as I said, we have a sample HOA agreement that we'll make available to you all, but there's a link in the slides here where we try to kind of recommend the right approach here for homeowners associations that want to have a hand in guiding the way solar is installed in their communities, but recognizing that they can't outright ban it. You can go to the next slide there. So I might just include a quick anecdote here of my experience with this. I've written a bunch of legal letters to homeowners associations on behalf of homeowners who, they want more direction on what they can and can't do with solar. And we've always quoted this, the property right statute. And basically what I had concluded after looking at this a bunch of times is the proper way to see that balance between the homeowners association right to regulate their communities and the property right statute was the issue of reasonable regulations or restrictions, right? And I always concluded in my legal opinions that an outright ban is not legal. That is clearly in violation of state law, but some way of articulating reasonable restrictions like setback requirements or like, perhaps even like the front of houses versus the back of houses, or something with an articulated regulation on solar with clearly thought out reasoning and guidance, I always concluded was arguably legal. And I think that's what is instantiated now in SB 820, pretty specifically. So as we said, times have changed for solar. Solar's a lot more widespread, a lot more accepted. I don't think it ruins the character of a neighborhood just by virtue of everyone being familiar with solar now. Not to mention it's a lot more financially profitable. If you can put some money down and borrow the rest, then your solar panels can pay off in a number of years and you're making money for something like 20 years afterwards. So it's a brave new world here, and HOAs have started taking action. But SB 802, as we just, sorry, that should say 820. SB 820 prohibits now homeowners associations from an outright ban on solar. And it requires this reasonable rules standard regarding the placement, regarding the process of obtaining approval. So we're going to be looking at what that means. Before this bill was passed, we got a ton of phone calls and inquiries and emails about this issue just all the time. People, homeowners associations, they tend to be in more affluent neighborhoods, and people who are affluent have some money sitting around and they want to invest in their house. That's not to say that solar is only for wealthier people, but people with money tends to be the early adopters of solar, and they tend to be most of the people who are putting up solar. Of course, renters can't put up solar because they can't make improvements to property they don't own. A lot of times this is just neighbor to neighbor spats about putting solar on, and you'd be surprised how passionate people can get about stuff that doesn't even affect them. But this is a really common issue that we ran into. Next slide there. Okay, so this was the standard I read to you. Key phrase there being reasonable rules subject to statutes. To the extent that the rules don't prevent installation, the function, restrict the use of, adversely affect the cost or efficiency, right? So that second part there is going to limit what type of what's going to be considered reasonable, right? There's plenty of flexibility built in here, but that does mean that it's likely that there will be litigation. Personally, I think we are in need of some regulations from the Public Service Commission here about what exactly is allowed, but I would anticipate litigation down the road here as we figure out exactly what all of this means. And this might be a good time, I guess, Tori, to pull up our sample HOA solar guidelines. Do you have that document handy?
Yes, let me share it.
Okay.
Um,
We will be sending this document out if you're curious to look at it. If you represent an HOA or as Tyrone said, you have some folks that you talk to with HOAs that are curious about what this means for them. I think this is a useful document. It's not
can you see it?
not controlling in any way. Yes, we can see that.
Okay.
It's obviously not binding. This is just our best guess. We're trying to be helpful and maybe taking a stab at what it might be to put some reasonable restrictions in place that don't run afoul of the new law. Okay, so you can go down here, a couple whereas paragraphs. Okay, so it defines what a solar energy device is. It clarifies we're talking about land owned by the property owner, not adjacent properties. The Architectural Control Committee, or whatever the HOA names that committee, can include 4 or 5 things here. We've said maybe a drawing by the contractor, some photographs, some list of materials used. And then the Architectural Control Committee can approve or request additional materials or recommend changes within reason. But you want to put in a date certain by which the ACC has to render a decision, right? That's important, so that these things are not just swallowed up in bureaucracy and loss, because that's another thing that provokes litigation here, which is our main goal is here is to limit that confusion and litigation and sort of streamline a process that everyone agrees to. Yeah, pre-approval or automatic approval we think is a really good idea. Spell out exactly if you meet these criteria, you're pre-approved, right? So there are as few one-off decisions being made by the ACC or applicable body as possible. That applies to, like, if you're going to allow ground mounts, here's how far they can extend. Potentially, your HOA could spell out the rear-facing roof as opposed to the front-facing roof. However, I would really caution against anything like that, because as we saw in the reasonable rules subsection there, you really can't do anything that outright restricts the ability to use or restricts the usefulness of panels. So if the sun faces south, right? The sun sweeps across the sky from the east to the west, but throughout the year, it's always biased south. So the ideal system is at from about 17 to 30 degrees tilt, south facing, if it's stationary. So if you're saying that all south facing houses can't install solar because you're saying that you can only install in the rear, well, I would say my legal opinion would be that that's an unreasonable restriction on solar because you really only use the south face of your roof. So keep that in mind, that you're always going to need to be guided by whether it's a reasonable restriction and whether your proposed rule is actually just an outright ban on solar. So keep that in mind. Okay, you can keep going down here. Let's see if there's anything else of note. Just a second. Okay, so there's other suggested language here about, you know, if devices are mounted on the roof, then how far can extend from the boundary of the roof. You know, it's basically a setback requirement. You can speak to where the piping or the conduit is exposed on the house, or whether it's possible to just regulate that it be at a particular portion of the house or in the back or something. You could reference shingles where they have to mimic a certain look. Although, as I said at the beginning, I don't really see solar shingles as a viable thing at the moment. There's no, Tesla makes them, but they're mostly a gimmicky product, and they're out west and not really in the Midwest. But maybe you want to speak to that for the future. So please refer to these guidelines if you're curious. I think it could be helpful. It's a good starting place if you're curious about what a good way to, be clear about your solar guidelines is without running afoul of the law. Anything else in there to mention, Tori? Yeah, providing for variances is a good idea to maintain flexibility. A way for a homeowner to seek a variance if they can prove a certain criteria are met. So anyway, we can go back to the presentation there. And a reminder to our attendees, if you have any questions here, please stop us. We'll provide about 10 minutes at the end there to discuss your questions, but happy to entertain them in the meantime.
Andrew, does that solar guideline that we just presented, is that something that you would give to the HOA to adopt, or like what is the dissemination of that?
Yeah.
Guideline?
Yeah, we'll see if we start getting inquiries from HOAs. I think we're happy to share that. They're all going to have to decide with their lawyers and with their leadership what they want to adopt. But I think the important thing to recognize here is, the legislature has spoken, and state law trumps local law, and most of the time, and it certainly trumps what types of agreements going forward can be struck between homeowners and their homeowners associations. So, this does decisively fall on the side of the property owner and their right to utilize solar, and anything that's going to materially and unreasonably interfere with their ability to use solar is going to be afoul of the law, right? So, I mean, there might be differences of opinion on that and whether that's warranted, but that is the law now. And around the margins, in terms of setback requirements, in terms of specific aesthetic looks, homeowners associations can still play a role. They still get a bite at the apple in terms of approval. If they want, they can spell out various criteria, but nothing that is really going to materially restrict homeowners' ability to install. And yes, I mean, we'll be happy to disseminate that sample guidance if people ask for it. Okay, so as I said, this law took effect August 28th, but it also spells out that enforcement doesn't take place till the 1st of next year. And it's yet to be seen what enforcement will look like. I mean, I think a lot of this stuff will have to be sorted out in the courts. I don't think there's going to be an agency tasked with doing a lot of affirmative enforcement, going out into the state and enforcing this stuff, but you can bet that there'll be some stuff before the courts to sort this out. I guess the thinking here was that they would delay enforcement here so that the real estate communities could get their ducks in a row, and that people working for homeowners associations could work on pulling together their reasonable rules in compliance with the statute. I got a question here from Tyrone Galgano. He says, I would like to receive the HO language guidance, please. Thank you. Yeah, yes, we'll be sure to send that out along with the recording of this presentation afterwards. And I would think that, you know, I'm sure there are HOAs out there that have loose enough language where it's all about how their ACC rules, and they don't actually, you know, legally need to change their HOA agreements, but we really would recommend it because you don't want a system where you're producing all of these inconsistent decisions, and it's producing litigation. So next slide. Okay, so here are some things to keep in mind when determining what's reasonable for restricting solar or regulating solar as an HOA. Location is incredibly relevant to solar. It's a technology that depends on, as I said, the grade and the direction of solar. So south facing, definitely, but maybe southwest is also something. I mean, that reduces the overall kWh, kilowatt hours, that are produced, but it shifts the production to the time of day when more consumption is happening if you go southwest or west. So, you know, that should be kept in mind. If you're restricting the east, you're probably okay. If you're restricting the west, you're probably less okay. If you're restricting the south, you're definitely not okay, because that's the most useful way to utilize solar. So this says surfaces do not face the street is okay. See, I might have a difference of opinion there. I mean, I think this is James, our executive director, who came up with this, and we'll see. I mean, I might even argue that it's not okay if it's a south facing surface facing the street. I might argue, you know, and there's a room for disagreement here, but I might argue that that is an unreasonable restriction. But we'll see what the courts say about all that. South or west facing portion faces the street. Oh, okay, I see what he's saying here. Okay, so yeah, if the south portion faces the street and the HOA guideline says you have to have it in the back of your house, you can't have it visible from the street, that's very likely an unreasonable restriction. It's possible that a rule could stipulate that the arrays can be allowed on the front of a house if you provide documentation, you know, that the solar company says it's the only feasible place, it's the only usable face on the property. Then maybe that would be a way to restrict street facing solar, is you have to provide this extra documentation saying it's the only way. Probably within the bounds of reasonableness. You could probably do stuff like require the concealment of wires or conduit. Again, you might have to allow for the homeowner to make a special showing of documentation that it's the only way feasible, right? And have the solar installer company sign off on that. Solar shingles, we talked enough about those. I don't really think that's very important. Yeah, next slide. Couple other things to keep in mind here. We're really talking about rooftop solar photovoltaic, PV, sometimes it's called. You know, that's where you're building right on your structure, the structure of your primary domestic structure of your property. Ground mount systems, while cheaper, are probably not protected in the same way under SB 820. With the exception maybe of if you've got a big property, several acres, back in the back corner of your 3 or 4 acres and you want to install a ground mount, it's not visible from the street. I can't see how restricting that is reasonable. It's not impacting the enjoyment of anyone's land. It's not producing glare on anything. I would think that that's a pretty safe ground mount system, but I do think that a homeowner association who restricted a ground mount system in someone's front yards is probably within the bounds of reasonableness. Again, unless that was literally the only place, the roof, the roof is totally unsuited for solar. There's no backyard. It's all about whether you're entirely restricting the property owner's ability to utilize solar. Okay, so a homeowner association rule should make clear that systems should comply with the net metering statute. We haven't talked about net metering, but if you're not familiar with it, in Missouri, it's called the Net Metering and Easy Connection Act. It's section 486.890 of the revised Missouri statutes, and that was passed back in 2007. And it's the foundational piece of law that allows any type of distributed generation customer, but really we're talking about solar, install and exchange power with their electric utility. So if they're overproducing, they're selling power to the utility. If they're underproducing, they're buying power from the electric utility, and they're getting compensated for that as spelled out in the statute. So it's important probably to reference that net metering statute and reference that you're not running afoul of it, that it's in compliance with interconnection agreements under the net metering statute. And also that they limit the size of the system that can be net metered. You can have a bigger system, but you can't exchange power with the utility. Local ordinances often require arrays to be certain colors, to have certain heights and conformance with a roof slope. I think that's all probably within the bounds of reasonable. Most panels are black. Okay, so there is a litigation history to this whole issue here that's worth knowing about. BAB versus Missouri PSC in 2013. I believe it got to the Court of Appeals. That's probably the one to know about. Obviously precedes our new statute. So this case, isn't going to have the impact that it did, probably because the statute's going to override it. But it does have some precedential value, so it's worth looking at. Basically, the Babs, who were a family that lived in Chesterfield Valley, I think. I'm sorry, Clarkson Valley, near Chesterfield. They wanted to install solar panels, so they applied for a special use permit, which was the designated way to do this with their homeowner association. The board denied it. Based on actually a local ordinance, a city of Clarkson Valley ordinance that addressed solar energy systems. So really the precedence for this goes beyond homeowners associations and it goes to local government authorities. So the Babs, looking at the 442.012 statute said, hey, we got a property right to do this. What the heck? So they filed in Cole County, basically saying that the local statute was preempted by the state one. And, pointing to other statutes like the Missouri Renewable Energy Standard and net metering and other things. And basically this local ordinance basically said, like, you have to use certain non-glare materials to limit the reflection on other people's properties or whatever. And these non-glare materials were going to explode the price of their system and were very hard to find within the solar market at the time. So it was in effect a ban on solar. Next page there. Okay, so what happened was they looked at a couple precedents, that basically said you can do a legal regulation locally so long as it doesn't prohibit what state law outright permits. Another one from 2009 was saying a city may only enact ordinances in conformity with state law on the same subject. The court basically looked at all this stuff, and they recognized that the state may have no concern and thus no restrictions regarding the use of reflective materials that might shine onto a neighbor's property, or the way the solar panels may appear from the street or a neighbor's property so as to devalue neighboring property. So basically it said that these restrictions were within the police powers or the local powers of the city. Next page there. Okay, so that actually there was more to that case. They did say more within the case, saying that while you could make certain reasonable restrictions in terms of like reflectiveness or whatever, an outright ban by a city like Clarkson Valley on solar would be in conflict with state law, because there's a net metering statute that offers the right to net metering. There's the solar as a property right statute and others. And they did say that an outright ban by municipalities is illegal. And that is still of precedential value, because this Senate Bill 820 that was recently passed this year only speaks to homeowners associations. So, outside of that, a city could adopt a resolution saying all people with left hands can't install solar or whatever, and we'd still have the problem of a local ordinance being in conflict with an area of state regulation. So that's the state preemption piece of that case. Interesting case to take a look at if you're curious. So we're about to the end of our hour here, and I'm happy to take questions if we feel like we didn't cover something that you were wanting to know about. Of course, we'll be sending this out with the recording and the link to our sample HOA Solar Guidelines document. But do we have any other questions from the folks on the line? Deanna says, thank you for the information. You're welcome, Deanna. Can I ask you, Deanna, what your interest is here? Or do you have any connection to this area?
Well, we didn't understand exactly what this information was about. I didn't know it was about homeowner. I thought it was about solar. But I did get information. We used to live in a homeowner's situation, and found that the architectural group, supposedly, that okayed what you didn't have anyone with any architectural experience. And my husband's an architect. So needless to say, we left that situation. We're now suburban or more out in the country a little bit, and we can do whatever we want. So it's great. And we're thinking about getting some solar. So I wanted more information about solar.
Yeah, no, that's great. I definitely encourage you to look into it and get multiple bids. Yeah, and I've talked to a lot of people in your situation. They got really fed up and they wanted to install, and it just became too difficult and expensive, and they didn't have the money to bring a suit against their homeowners association. I mean, there's nothing against homeowner associations. They're locally managed. It's people within the community that usually sit on these boards, and they're not experts in solar. They're often not even, they might be on the architectural control committee and not be architects themselves. I mean, in most cases, that's going to be the case. So it's just important that they have as much guidance and that they know where the legal boundaries are so that they know what's within their purview and what they're allowed to regulate. Liz, thanks for your comment here. You say this is very informative. I'm excited as a homeowner to convert my Kansas City almost 100-year-old home to solar and water reclamation. Very cool. Love to hear more about that project. Do you live in a homeowners association, Liz? You do, okay. And do you guys have a procedure by which you have to seek approval or anything like that? Okay. Liz says she's working on it. Well, good luck. Obviously you have the information now. You can reference. So it's Senate Bill 820, but the section of law is section 442.404 revised Missouri statute. So that might be important for you to remember, and looking forward to hearing from you if you encounter any difficulties there. We'd be happy to advise. Thanks a lot, Tyrone. I think that's about it for us. We've come to the end of our hour, so we'll be sending this out. And for everybody watching back on recording, thank you for listening. And please stay tuned and follow Renew Missouri. We'll be doing a couple more of these CLEs throughout the year, and we appreciate your support. So thanks.